Are you moving into a new place? Have you been handed a 1-page or a 10-page lease agreement and you've been asked to sign? Do you not understand the legal language that is contained in the lease deed? If this is your situation, then worry not, you're in the right place. Today I'm going to talk to you about 11 clauses that should be there in any lease agreement. My name is Ramana Reddy and I am a practicing lawyer in the High Court of Telangana, and I help you by simplifying legal concepts. For more tips, tricks and general legal advice, be sure to hit the subscribe button below. So before we get into what are the clauses in a particular lease deed, it is first important to think about why should you enter into a lease deed. I mean, there are so many people who rent property without a lease deed. So why should you bother with a lease deed? Now, the reason behind this is because of a section in the Transfer of Property Act called Section 106 of the Transfer of Property Act, which basically says that in the absence of a lease deed, a landlord can give you 15 days notice and kick you out of the property. So if you don't have a lease deed, you face a risk where you may be thrown out of that property with notice of just 15 days. So as a tenant, it is not safe for you to enter into a lease without a written lease agreement. Now, as a landlord also, although there is a benefit that you may be able to kick the tenant out in 15 days, if there are disputes with regard to what was the rent that was agreed between the parties, how long was the lease deed originally agreed, or what was the duration of the lease and so on. As a landlord, you may, for example, for the lease rent, you may have to show just the bank deposits. But if you had a lease deed, you could just rely on that lease deed and you could show that to the court. So generally speaking, it is more beneficial to have a lease deed than not have a lease deed. Now, having said that, now let's get on with the clauses or with the actual content of a lease deed. What are the 11 things that you must have in a lease deed? The first one that you must have, a lease deed always starts with the names of the parties. So to take an example, let's say, I, Ramana Reddy, I want to lease a particular property for a residential purpose. So the first thing the lease deed will say is, let's say, one Ajay Kumar Rastogi is the landlord. So it will say this lease deed is being entered into by and between number one, Ajay Kumar Rastogi. The whole purpose of this is to identify the parties with precision. So not just giving names. So you will say, Ajay Kumar Rastogi, son of so-and-so, resident of so-and-so, age so-and-so, occupation so-and-so, PAN number so-and-so, Aadhar card number so-and-so. This is being entered into between Ajay Kumar Rastogi and all these details. And I, Ramana Reddy, with resident of so-and-so, son of so-and-so, age so-and-so, occupation so-and-so, Aadhar card so-and-so, PAN card so-and-so. The whole purpose of this is to identify the parties and also to give them a short label so that whenever we're referring to these parties, to Ajay Kumar Rastogi and to Ramana Reddy, in the following terms of the lease deed, then it becomes easier. So what we'll say is, Ajay Kumar Rastogi hereinafter called as the landlord, I Ramana Reddy hereinafter called as the tenant. So that is the first clause in a lease deed, which is not technically a clause, but the first thing that goes into a lease deed are the names of the landlord and the tenant so that we can identify the parties as to who are getting into the lease deed. Now, the second clause, or not technically a clause, but this is the second thing that should go into a lease deed, that is the recitals. Now, what is a recital? A recital basically is what are the circumstances that led to the making of this lease deed. So in this particular case, it may say Ajay Kumar, whereas Ajay Kumar Rastogi is the owner and occupier of a building situated at so-and-so locality in so-and-so city, which, house number so-and-so with pin code number so-and-so, and he's the absolute owner of that property. Next, you will say, whereas Ramana Reddy is looking to rent a piece of property for residential purposes because he has found a job in a particular city. Therefore, both these parties have now agreed to enter into the present lease deed. So as you can see, the recitals component talks about the circumstances which led to the lease deed. So on the one hand, the landlord is the owner of a particular property. On the other hand, the tenant is looking to rent that particular property. And now both of them have agreed and they've come together to enter into the present lease deed. So the names, second one is the recitals. Now going on to the actual clauses now. So the first clause should be, what is the term of the lease deed? Is it 1 year? Is it 2 years? Is it 5 years? What is the term for which you are looking to rent that particular property? Now, a common mistake is in defining the term of the lease deed. So let us say that it is for 12 months. You are mentally thinking, okay, I signed the lease deed on the 1st. I'm going to move in on the 5th. Now, does the lease deed start from the 1st or does the lease deed start from the 5th? What is the effective date of the lease deed? And this is something that has to be thought about in advance so that we know what is the start date of the lease deed and what is the end date of the lease deed, so that there's clarity as to what is the term of the lease deed. Now, that is the third clause in the lease agreement. Now, the fourth one is a related term, which is a lock-in period. Now, not every lease deed has a lock-in period, but for example, a lot of commercial leases have lock-in periods, because suppose a business person leases a piece of property to run a restaurant. He will do a lot of interior work. He will put a lot of money into the property. So he wants to be assured that he will be able to enjoy the lease deed at least for a few years. So if it's, say, a 10-year term, then he may say that at least the first 3 years should be locked in, where I cannot terminate, you cannot terminate, or maybe I can terminate if the business is not working. But as the landlord, you should not be able to terminate. And that is a lock-in period. In residential leases, this is not a common practice. It may be a case where the landlord is actually looking to lock in a tenant instead of the tenant looking to lock in the landlord, like the restaurant. But in a residential lease, the landlord may be more interested in getting hold of the tenant for a longer period. But this is more common in a commercial lease as compared to a residential lease. Now, but the landlord has another important way to get hold of the tenant, and we'll get to that in a minute. The next one is the rental amount. What is the rental amount? Is it 30,000 a month? Is it 50,000 a month? Is it 1 lakh a month? What is the rental amount? And preferably it is advisable. So if it is, say, a 2-year or 3-year lease deed, and say there's a rental increase every year from, say, the first year is, say, 100 rupees, the second year is, say, 105 rupees, and the third year is 110 rupees, then it is advisable to have each month laid out and the amount that is payable for each month, so that there's clarity going in for each month what is the amount that is payable. Now, another important thing to keep in mind, like I just said, how does the landlord exercise control over the tenant so that he stays there at least for a minimum period of time? What he does is that he takes an advance. Now, the quantum of advance differs from place to place. In some cities, landlords insist for a 6-month advance. In some cities, landlords insist for a 3-month advance, and so on. It may vary from place to place. Now, it is important to understand that there's a difference between an advance and a security deposit. Let us say you've given an advance of 2 months. So basically, what that means is that you will pay rent from January to October, and November and December you will enjoy rent-free period because you've already paid an advance of 2 months. So you will tell the landlord, you already have my advance of 2 months, so just adjust the rent for those 2 months with the advance that I've already given you. This advance arrangement favors the tenant. On the other hand, if the advance is called a security deposit in the lease deed, then things change. So what would happen is, if you take the same 12-month example from 1st January to 31st of December, then what would happen is the landlord would say, okay, you would have to pay for the entire 12 months. At the end of the 12th month, I will come back and I will inspect the property. Once I'm satisfied that there's no damage with the property whatsoever, then I will repay you your security deposit. So as you can see, a security deposit favors the landlord and advance favors a tenant. So, use your best judgment if you're a tenant or a landlord, and you can adjust the clause accordingly. Now, there are other issues also with rental amounts, which is if, is it with tax or is it without tax? So if I pay 30,000 a month, is that inclusive of GST or is that exclusive of GST? Generally, in a residential lease, there is no GST. The GST is nil unless I am working with a company where the company has a GST registration and and the company is paying for my rent. Then in that case, then the company is liable to pay GST because it has a GST registration. So in those kind of cases where the company is paying for the employee the rent, then when you are entering into the lease deed, it is important to write whether 30,000 is inclusive of GST or the tenant has to pay 30,000 plus 18% GST. What is the situation with tax? Now, the other thing to keep in mind, this is something that is for the landlords, which is rarely enforced, but at least they do this to scare tenants, which is, if you don't pay the rent on time, then we will charge you late fee. I will charge you 1% every month for late fee if a fixed amount for these many number of days. And this is a tool that landlords use to make sure that you pay on time. The other thing to consider when you are talking about rent is whether rent is paid in advance or whether rent is paid after the month. It's generally paid in advance, but that is again up for negotiation. So if you're the landlord, then you may say, okay, if you're moving in January, January's rent you need to pay by the 5th of January. On the other hand, if you're a tenant and you can negotiate, you can say, if I move in January, January's rent I will pay in February, February's rent I'll pay in March, and so on. So is it prepaid or is it postpaid? That is another thing to think about when you talk about the rental amount. The next thing to look at is what is the usage of the property. In a residential lease, the next clause, so if you're keeping track, this is the 6th clause. How is a tenant going to use the property? If it is for a residential property, it will say that Ramana Reddy is only going to use this for a residential property and he's not going to start a business out of here, or he's not going to start displaying signboards on the windows and so on. So just so it makes clear what is the purpose of the lease when it is entered into. Now, the next one is what are the obligations of the respective parties? Now, it may be that, what is the obligation of the tenant, for example? Maybe that the tenant must pay the water bill, the tenant must pay the electricity bill, the tenant cannot make any civil alterations, like he cannot break down walls and so on. He may be able to do some interior work, but you cannot make any structural changes to the property. The tenant must give back the property to the landlord as is, in the same manner as it was leased out to him. So those may be the obligations of the tenant. Now, on the other hand, what may be the obligations of the landlord? The obligations of the landlord would be that he has to ensure that the tenant is able to enjoy the property in a peaceful manner, that he is actually the owner of the property. So the landlord has to give a representation to say that, yes, I am the owner of the property. Yes, nobody will disturb your peaceful possession of the property. And, you can enjoy the property for the purpose for which it is let out to you. Then, generally property tax on the premises is generally paid by the landlord, but that is not always the case. Even that also differs from time to time. So, but generally speaking, landlords pay the property tax. So again, what are the different obligations that you are looking for is something to be talked about in this section. Now, the next one is the tenant permitted to sublet or assign the property to a third party? So, for example, if I enter into a lease deed, can I sublet, or if I enter into a lease deed for a 2-bedroom flat, can I get another tenant in the other bedroom and where we get to share the rent and both of us can pay the landlord? And this is something that will have to be thought of in the lease document. Generally, landlords don't like it. They don't like tenants to be able to sublet or assign the lease rights to a third party. Even if such clauses of subletting or assignment do exist, the landlord may insist for prior consent that without my prior consent, you cannot lease this property to a third party. Now, if it is a business, maybe you have a better argument in that if I'm not able to run the business, I should be able to at least let it out to a third party. So let's say, for example, I am a doctor, I have a clinic, I'm a cardiologist, and there's a related medical field, and I feel that if I can bring another expert into the clinic and he can also run his clinic, then both of us can do well together as partners. Maybe in that case, you have a better case to make to the landlord as to, I will only give you prior notice, but I will not take prior consent from you. I will only give you prior notice, and I should be able to sublet the property to a third person. Even in that case, the landlord may say, okay, fine, only notice. But if the other person, only you will be liable. You, cardiologist, will be liable to pay the entire rent. If the other person does not pay or if he does not pay his share of the rent, I don't care. It is only you who has to pay. So that is something to be thought about depending on whether you're the landlord or the tenant, and if you're actually looking to sublease the property or not. The next one is termination. Now, termination of a lease deed is generally of two types. You can terminate the lease deed either through convenience or through breach. Now, let's talk about breach because that is simpler. If the tenant does not pay rent for, say, 2 or 3 months, the landlord can ask the tenant to leave. So let's say if the tenant does not pay for 2 months, the landlord will issue a notice to the tenant. And if the tenant, within 7 days of receipt of that notice, fails to clear all the arrears of rent for the last 2 months, then the landlord can issue a notice to the tenant asking him to leave. Similarly, if then the tenant can issue a notice to the landlord and say, I'm leaving because you have breached the lease deed. You said you are the owner. You said I can enjoy peaceful possession of the property, but that is not happening. Therefore, because, depending on who's issuing the notice to whom, because the other party has breached the lease, we are getting out of the lease. So that is termination for breach. Now, the second type of breach is termination for convenience. Termination for convenience basically means that I can terminate the lease deed just because it's not working out for me. So let's take a case where an employee moves in for a residential lease in a new city. The employee may think, well, if I get a job somewhere else, I should be able to leave with a notice of 1 month or 2 months to the landlord, generally equivalent to the advance that was already paid to the landlord. If I pay for 2 months, then generally termination, the notice period is 2 months because he has 2 months of my amount. Or if suppose there's COVID, who knows, and you want to get out. So then there's generally a notice period that is attached. The tenant wants to leave. Same case for the landlord. If the landlord says, look, if I want you to leave for whatever reason, just for convenience, then I should be able to give you notice of 2 to 3 months and you have to leave. Now, as a tenant, if you're worried about the landlord kicking you out in a few months, then you should seriously contemplate putting in a lock-in period where, he will not be able to terminate. So these essentially are the 11, or I've talked about 10 so far. The 10 clauses that should be included in a lease deed. Now, the 11th one is technically not a clause, but it is always important that you register your lease deed. Now, there is some misconception that if the lease deed is for 11 months or if the lease deed is for less than 11 months, there's no need for registration. That is not true. Even if the lease deed is for a single day, you need registration. Now, I understand that in many cases, the landlords are not willing to register documents because they don't want to be bound by it. Even in those situations, even if there is no registration, it is still advisable at least to have a lease deed, because when you go to court tomorrow, even though the document may not be strictly admissible in evidence, you can still use it to show some other things. So let's say, for example, if you want to show that suppose the lease deed says that the rent amount is 30,000, but the lease deed is not registered, so it is not admissible in evidence. I mean, you can't just read the lease deed and say, oh, this is the truth. But what you can do is you can prove the 30,000 by showing that I have deposited 30,000 every month into the bank account of the landlord, and the lease deed says that it is 30,000. And if it's for more than 1 year and you've given a table for each year as to each month, then you can show with with bank statements that I have deposited so much. And so there are external ways to prove a lease deed, even though the lease deed itself may not be admissible in evidence. So it is always advisable that you at least have a lease deed signed by both parties, and that is very important. And there's, just as a bonus, there's one more thing that the lease deed needs, which is the schedule of the property. So towards the end of the lease deed, you will put a schedule of the property where you identify the property. So generally what you do is you ask the landlord, to copy the schedule of the sale deed through which he purchased. So, there must be a property through which he purchased the property that he's now renting to you. So you can ask him to get that piece of to get that document out, so that you can copy, it will say, so all that in survey number so and so in this village with the, bearing in so and so area, this pin code number, this district, and so on. So that the identification of the property is very clear. So it may always say, first floor and so on. Just so that we know what is the exact property along with the square feet that is being leased out to you, so that tomorrow there's no dispute about, I leased only this part of the property to you, not that part of the property to you, and so on and so forth. If you enjoyed this video, please hit the subscribe button to receive helpful legal tips. Thank you for watching.